Good evening. I am Rida Zaman, a student of LLM International Commercial Law in Dispute Resolution, bearing student ID number 2211427, and today I shall be presenting on my dissertation proposal. I shall start with a brief introduction of the topic, starting with the topic name. The prevalence of pro-enforcement bias in international arbitrations and a detailed discussion on the enforcement of international arbitrations in Pakistan. As the name suggests, the topic shall aim to study the pro-enforcement policy in Pakistan and the judgments of and some prominent judgments of the Apex Court over the years. It shall also focus on the pro-enforcement policy globally and internationally. It shall also study the exceptions ruled out under Article 5 of the New York Convention 1958. Background. What is pro-enforcement policy? Pro-enforcement policy stops the domestic abuse of legal system. It merits that the review of an award undermines its finality and enforceability. It prioritizes enforcement of international arbitral awards and reduces or minimizes local tendencies from interfering with the enforcement of arbitral awards. The courts of England and Wales have also recognized and upheld the principle or the policy. Next slide. The United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or commonly known as the New York Convention 1958, sets out certain limitations or exceptions which can justify annulment of an arbitral award. For instance, Article 5, Subclause 2 of the New York Convention 1958 provides that an arbitral award may be set aside by the court if it is against the public policy of the state under which its enforcement is being sought. Section 103, Subclause 3 of the English Arbitration Act mirrors with Article 5, Subclause 2 of the New York Convention, and it provides that an award can justifiably be annulled if it is against the public policy of the Court of England and Wales. However, as referred in the slides, in Jansen versus Consolidated Mines case, Lord Halsbury took a contrasting view and he shrank the scope of public policy. And he shrank the scope of this exception. Pakistan, although had a turbulent relationship with enforcing international arbitrations in the past, for instance, the famous case of Titian Cooper versus Federation of Pakistan or the famous Bricodec case, it is now more inclined towards a pro-enforcement policy and the state is taking some progressive steps. For instance, a justice of the Supreme Court in 2021 SCMR 1728, as also referred in the PPT slides, has held that Pakistan is yet to develop jurisprudence on international commercial arbitration, and it ought to take steps which are in line with international community. Reasons to choose this topic. The study shall aim to focus on the enforcing international arbitrations in Pakistan. As discussed in the former slides, Pakistan has had a turbulent relationship with enforcing international arbitrations in the past, and Pakistan did not have a good reputation when it came to enforcing international arbitrations. The state is yet now taking some progressive steps. It is very primitive and it is vital and significant that a state does take concrete steps, because the state cannot function in isolation, and to foster economically and to have a better repute in the international business community, the state needs to take steps which will adhere with the enforcement of international arbitrations. To foster economically and diplomatically as well, the state needs to take concrete steps, and the state needs to take significant steps for enforcing international arbitral awards and to gain the trust of the international investors. Research questions. I have divided the research questions in 7 parts. Number 1. How does the concept of pro-enforcement bias relate to yield in enforcing international arbitrations? Number 2. How does Article 5 of the New York Convention relate to the pro-enforcement policy? Number 3. Where does the policy stand in Pakistan? Number 4. How has the policy evolved over the years? Number 6. Is the Recognition and Enforcement of Foreign Arbitral Awards Act 2011 potent for enforcing international arbitrations? Number 6. What are the shortcomings in enforcing international arbitrations? And number 7. How can these shortcomings be effectively minimized? Which will be the major question of the dissertation. Moving further, next slide, that is research objectives. I have mentioned some of the research objectives in the PPT slides. However, I believe that the major objective of this dissertation will be to draft the best possible recommendations for enforcing international arbitrations in Pakistan. Issues. I have also discussed some issues in the PPT slides, and I still believe that the major issue is the dilemma of enforcing international arbitrations in Pakistan. Research methodology. I shall focus mainly on the analytical research methodology and the doctrinal research methodology. For that, I will review and I will refer and I will read some of the former written articles, academic literature, academic writing, references, case laws, etc. Methods and tools. I shall obviously use some primary legislations, for instance, the Arbitration Act in Pakistan on enforcing international arbitrations, the New York Convention. I shall study some of the some of the prominent case laws in Pakistan, also around the world, some global best practices. I shall resort to JSTOR, SSRN, Google Scholar, Westlaw, the e-library of University of Bedfordshire, Cambridge Press, Oxford Press, and certain other reputable forums. Literature review. What is literature review? Literature review is a review of already written academic literature. I have referred some of the articles in the slides. I will briefly discuss some of them here in the presentation. Number 1. Pro-enforcement bias under Article 5 of the New York Convention in International Commercial Arbitration, a comparative overview written by FIFA Junita. The author augments that the exceptions granted under Article 5 of the New York Convention in enforcing international arbitral awards are to be construed in a narrow manner, and these exceptions do not grant the courts with powers to undermine the credibility and enforceability of foreign arbitral awards. The author strongly feels that the exceptions provided are to be construed very narrowly, and every court has to take cognizance of the fact, it has to take this in mind, that the enforcement of an arbitral award should be the foremost priority. Secondly, we have this article. I have this article titled as "The Principle and Practice of International Commercial Arbitrations," written by Margaret L. Moose and published by Cambridge University. The author has the same view. He is of the view that the exceptions provided under Article 5 of the New York Convention are to be construed in a narrow manner. It does not give arbitrary or undue power to the courts to annul an award, or unjustifiably annul an award, or to widely just annul an award on the ground of it being against the public policy. The courts have to take a narrow view, and the courts have to uphold the arbitral award and the courts have to try to uphold the enforceability of an arbitral award. The author also mentions that for enforcing international arbitrations is comparatively easier than enforcing national arbitrations because of the New York Convention, and the New York Convention specifically dictates, the New York Convention is in favor of enforcing arbitrations. Furthermore, I have this article written by Hassan Raza, an advocate of Pakistan. This is published on Clover Arbitration blog. It is titled as "Pakistan's Dilemma with Foreign Arbitrations." The author has also mentioned some writings of a former Chief Justice of Pakistan, in which the Chief Justice has also highlighted that Pakistan is in dire need to have a better mechanism for enforcing international arbitrations, and that the New York Convention also dictates on enforcement of international arbitrations. And since Pakistan is a signatory to it, and Pakistan has its own act on enforcing international arbitrations, Pakistan has to take significant steps towards a pro-enforcement of arbitral awards approach. Then I have referred this article written by Ahmed Abdul Rahman and Nafe Mohsin. The article, the authors they augment that the exceptions provided, they are limited, they are narrow. The authors also project that the jurisdiction granted to high courts in Pakistan under the Act of Recognition and Enforcement of Foreign Arbitral Awards is very limited, and the courts have to bear in mind that bear this in mind and have to promote enforcement of arbitral awards to the utmost. Lastly, there's this article written by Ariba Rashid. Ariba Rashid is not very Ariba Rashid is not very optimistic about the enforcement of arbitral awards in Pakistan, and she believes that the path is hazy, it is not up to the mark, and the state has to take some concrete steps. I have referred some books as well. They're mentioned in the slides. There's this one book written by titled as Recognition and Enforcement of Foreign Arbitral Awards, a global commentary on the New York Convention. There is this other book as well, which is published by the Kluwer Law, and thirdly there's this book which is authored by Ikram Ullah, that is the arbitration law in Pakistan. Apart from these books, certain other books will also be referred and will also be used up in the dissertation stage. Next slide. Cases. I have referred some cases in the PPT slides. For instance, Soleimani versus Soleimani, or the Ricodic case, or the Titian Cooper versus Federation of Pakistan, or Jensen versus Consolidated Mines case, certain other cases as well along with these cases. I shall refer and I shall use more cases as well in the dissertation stage. This is not conclusive. These are just being used up in this stage. Lastly, I've mentioned it in the slide as well that the references used in these PPT slides and in this presentation, they're not conclusive. I will refer to other sources in the dissertation stage as well, as I have depicted in the slides and as I have mentioned in the presentation as well. The major focus of the study will be to study the pro-enforcement regime around the world and the pro-enforcement policy in Pakistan. What steps has the state taken so far, and what other necessary steps the state should take, and how does Article 5 relate to the pro-enforcement policy, and how can the policy be effectively be implemented in Pakistan. I hope you enjoyed the slides and the presentation. Thank you.